It's recorded. Yeah. So David, please.
Welcome, everybody. We're so thrilled for that all of you can join, and people are still joining. And it's a really special occasion to be able to host Professor Martha Minow. These are tough times in Jerusalem and in Israel, and we take solace in being able to study and to think about the values that keep us going, and hopefully that help us better society. And I think no better person to invite than Professor Minow and the topic at hand about how we can try to do our work to try to improve where we are. There's a lot of work to be done. Professor Martha Minow is the 300th anniversary university professor at Harvard University. She's been at the Harvard Law School since 1981 and was the dean there for almost a decade, 2009 till 2017. An expert in human rights, constitutional law, advocacy for members of racial and religious minorities, for women, children, and people with disabilities. It's a long intro, so I'm just going to read some highlights. I hope that's okay. Professor Minow is a fellow of the American Academy of Arts and Sciences since 1992. She's been a senior fellow of Harvard Society of Fellows and numerous other boards and committees. I think relevant to today's lecture, Professor Minow served on the Center for Strategic and International Studies Commission on Countering Violent Extremism and on the Independent International Commission for Kosovo. And again, on numerous other commissions and federal boards and entities, really combining the academy with trying to improve society. She's also the recipient of 9 honorary degrees in law, education, and humane letters from countries around the world. And she's the author of numerous books. I'll just read a few highlights. I guess working in chronological order, Making All the Difference, Inclusion, Exclusion in American Law for 1990, Between Vengeance and Forgiveness, so the theme of forgiveness, Facing History After Genocide and Mass Violence in 1998, In Brown's Wake, Legacies of America's Constitutional Landmark, 2010, When Should Law Forgive, which is the basis of today's lecture, in 2019, and forthcoming next month, Saving the News. So that's the next time she comes, and hopefully she could join us in person the next time. She for sure is invited, and that invitation is extended. So it's a great honor for us to invite Professor Martha Minow to share remarks. She'll speak for about 40 minutes, and then we'll have time for questions, discussion. So you could also send me in the chat or send Benny in the chat questions and comments, or raise your hand. Professor Minow.
Thank you so much, and for the invitation and the lovely introduction. I am not a Jewish law scholar. I wish I were. I was telling Benny just before we started that I had the good fortune to study with Robert Cover, and he introduced me, and indeed so many others, to the possibility of drawing connections between Jewish law and secular law. So it's something that I have a lot of interest in, but my work is only marginally informed by Jewish law, except it is informed by my own upbringing and what I've learned. So I've been very interested in the question of forgiveness, and I will confess that many of my colleagues here at the law school at Harvard said, "Why are you writing about this?" And for me, it was an obvious thing to write about. So I guess that does reflect something about my own background. I've been interested in asking, can and should law and legal institutions and processes prompt or discourage individuals to let go of resentments and grievances? Should judges expect or reward apologies? Should prosecutors, judges, administrators themselves forego justified legal action and sanctions? And of course, you know, every year at Yom Kippur, Jews around the world and across time think about forgiveness and ponder interpersonal and religious dimensions. How many Torah studies struggle with forgiveness? Joseph and his brothers, the Jubilee, releasing prisoners and releasing debt. In the Talmud, Abraham forgives Abimelech, who wanted to rape Sarah. I've always wondered, did Sarah forgive him? Seems like a different question. I'm not sure Sarah ever forgave Abraham for thinking of sacrificing Isaac. That's a whole other subject for another day. But writing about law and forgiveness, Moshe Habertal explains that there's an important role of a direct encounter, that's very hard to forgive from far away. And I have been thinking, and here's a bridge to my next book, about the effect of social media and the ways in which it's hard to be forgiving when you are looking at a screen instead of at a person. There are limits to creating institutions that demand forgiveness or expect forgiveness. And I think that the relationship between emotion and norms is also very much involved in this subject. I have been very preoccupied for quite some time with accountability as one of the promises that law offers as an alternative really to revenge. Accountability, having mechanisms for accountability rather than revenge, that is law's contribution to civilization. I wrote a book, as David mentioned, some time ago, comparing the use of international criminal tribunals and truth commissions and reparations as responses to mass atrocity and violence. And I called it Between Vengeance and Forgiveness because I really thought of those institutions, those practices, as finding a path or a bridge between terrible past and a future without letting loose new spiraling waves of revenge and vengeance. Now there's even a field, transitional justice, to describe this kind of work. But when I talked with people about that prior book, many people around the world would say to me, usually lawyers, why are you, usually they were not lawyers, why are you looking for an alternative to forgiveness? Isn't forgiveness something that's admirable? Isn't it something that society should encourage or enforce? I am using forgiveness to me, letting go of justified grievance. And it is true that grievance is the wellspring of a sense of justice. So I don't think grievance is bad necessarily, but revenge can spiral out of control. And acts of forgiveness can be admirable, and yet expecting someone to forgive can be another kind of violation for someone who has already been victimized. Nearly 2 years ago, a vivid moment played out before public eyes in this country. In September of 2019, a police officer in Dallas, Texas, named Amber Geiger, received a sentence for murder after she committed this heinous act. The victim's 18-year-old brother, a man named Brant Jean, on the televised event of the sentencing, forgave the defendant. And I joined others around the country and watched in awe at that act of grace. But I also worried, and I worried that Black people like Brant Jean are expected to forgive in ways that others are not. And that Amber Geiger, a white police officer, received a lesser sentence than others do for wrongful killings. But because I'm a law professor, I also worried about law. And I worried about the ways in which, at least in the United States, our criminal system leans so heavily towards punishment that that's part of the problem. The powerful example of one individual forgiving is a really striking comparison with the ways that lawyers and officials too often overlook the room for forgiveness that is afforded within the legal system itself. I worry that lawyers and officials do not adequately use tools to let go of justified grievances, tools such as pardons, commutations, bankruptcy, discretion held by police officers, prosecutors, and judges. But I also, of course, worry that when that discretion is used, it can too often replicate existing social inequities along lines of race or class or religion and other markers of advantage and disadvantage. Bias and privileged access is at work when presidents in the United States use their discretion to pardon people charged with crimes. Historically, white people have received presidential pardons 4 times more frequently than Blacks, even controlling for the same type of crime and sentence. Forgiveness is relevant to law, in my view, in 2 ways. We can ask how legal institutions and practices affect whether people forgive one another. Do the laws nudge people in that direction or push people away, maybe through adversariness? Does the law bring people together or separate them? Does the law make apologies grounds for lesser criminal sentences or instead use apologies as evidence of guilt? But the second way is that forgiveness, this letting go of warranted grievance, can be practiced by the legal officials and institutions themselves. And when should those be used and how? Forgiveness between individuals is supported by every religious and philosophical tradition. It's also supported by studies of health benefits to those who let go of resentments through forgiveness. Nelson Mandela led South Africa's peaceful transition from apartheid to democracy and explained, and I'm quoting him, "Resentment is like drinking poison and hoping it will kill your enemies." Now, one way that law can be relevant is law can remove penalties for those who do apologize and seek forgiveness. In the United States, 36 of the 50 states allow medical professionals, for example, to say they are sorry if there's been a bad outcome without having that acknowledgement used later in a civil lawsuit over financial liability. More actively, bankruptcy law can offer debtors, under some conditions, the chance to start anew. And pardons, I've already mentioned. I've been teaching for 40 years. I realized in thinking about this that we don't typically teach in law school about the tools of discretion and the use of pardons, for example. This is a lost opportunity because the students that we teach will become prosecutors and judges and lawmakers. One of my former students, Barack Obama, used his pardon power as president of the United States. And he used it to release several hundred people from prison after the law changed to provide shorter sentences for the drug crimes for which they had been convicted. And I think that was a good use, but he did not use the pardon power very extensively, and he has come under criticism for that. Legal tools of forgiveness, I think, should be used more than they commonly are, but not without reasons and not with bias or prejudice. There's a cartoon in the New Yorker that shows, the New Yorker magazine, that shows a judge with a very big nose and a big mustache looking down from the bench at a defendant with a very similar nose and mustache. And the judge says, obviously not guilty. I mean, this is the danger, right? That if you actually exercise discretion, you will consciously or unconsciously show bias, familiarity, and maybe less generosity towards those that you don't identify with. Forgiveness more powerfully can undermine central legal commitments to apply rules evenly. In a time of mass incarceration, consumer debt, we could use more legal forgiveness, but I think we need a jurisprudence of forgiveness. We need a philosophy about when and how law should forgive and do it fairly. I've been thinking about this particularly in the context of international criminal law. Child soldiers is a subject that becomes a chapter in the book that I published on this subject. International human rights law condemns and punishes adults who involve children in armed conflict, as the adults are the most responsible. Human rights law also tends to treat the children themselves quite differently. The International Criminal Court convicted Thomas Lubanga, the warlord from the Congo, for enlisting and recruiting children as soldiers. But most nations in the world commit to ensuring that people under the age of 15 do not engage in hostilities. And if they do, they're not punished under criminal law internationally. It's hard not to contrast that with what happens in the United States with people of the same young age. Juvenile justice severely punishes minors, often sent to adult courts and adult prisons. And yet, like child soldiers, children and teens are drawn into violent activity in the United States when there are few options, when they are threatened, when they are induced by adults. The rhetoric of innocence resonates in the context of child soldiers. It's usually missing in the context of gang members in the United States. And yet in both settings, youth are caught in worlds that are made by adults. And I wonder about forgiveness. Can it offer accountability and a fresh start? But we shouldn't oversimplify. To look more closely at the topic of child soldiers, it's fair to say that around the globe, many children are abducted or coerced into becoming soldiers, but some join armed conflicts voluntarily. Some are drawn by ideology. Some are drawn by the opportunity for action and responsibility, or even the thrill of committing violence. And some who join under coercion later kill and rape. These actions may reflect pressure and fear, but also some degree of choice. And should that degree of choice make them culpable? Are they blameworthy? When should they be forgiven? You know better than I do how these issues play out in your world. Some legal theorists would say forgiveness is not the right concept if you're talking about minors. Instead, we should talk about excuse or diminished responsibility, or presume that people under a certain age lack intention or control required for full criminal responsibility. But regardless of what the particular legal rules are in a jurisdiction, it's difficult to deny that even minors can make choices, and that a 15-year-old's life looks more like that of an adult than does a 3-year-old. One adolescent soldier explained to a researcher that he planned to return to Liberia so that he could claim benefits that were being granted to demobilized child soldiers, but then he intended to return to fighting if he could not obtain enough financial support. Some children in armed conflicts demonstrate choice in their involvement and stay even when they have opportunities to leave. Should that matter in terms of their subsequent treatment? And these different degrees of choice make this issue about responsibility and forgiveness especially complicated. Ironically, viewing child soldiers as innocent may make forgiveness beyond reach, because forgiveness is for those who have committed a wrong, rather than actually seeing child soldiers simply as victims or wrongdoers. I think it would be helpful to view them as individuals trying to make meaning of their experiences, including their past wrongdoing. Many former child soldiers struggle with whether they can forgive themselves for what they did. One, whose name is Emmanuel Jal, became a musician and a rapper, and he wrote these lyrics: "I'm in another war. This time it's my soul I'm fighting for." Self-forgiveness and community acceptance are important dimensions of reintegrating a former child soldier. And again, I think there's a lot of parallels when we come to juvenile offenders in my own country. There may be lessons to draw in how we construct juvenile justice. And I think that there could and should be opportunities for young people who engage in crime to take responsibility, but not face the same punishments that apply to adults. And I'm intrigued by the development of restorative justice mechanisms in the United States. Our Supreme Court has been ambivalent. On the one hand, it has said that the assignment of punishment of life without parole for anyone convicted of a crime committed before the age of 18 should be a case by case, and there should be opportunities to revisit that punishment. But the court recently backed off of that view. Restorative justice, in contrast, takes the treatment of wrongdoing entirely out of the formal legal system. And many schools in the United States now use restorative justice to resolve or even prevent conflicts and curb delinquency, disrupt what's been called the school to prison pipeline in many communities. In restorative justice practices in schools, a leader who is often a student learns to de-escalate the conflict and orchestrate conversations about what the offender can do to make amends, to pay restitution, to help the victim, and to avoid future conflicts. I'll give an example. Mercedes M. was a young woman enrolled in a California high school after she was suspended from her prior high school due to too many fights. Two of her classmates one day called her a liar, and a facilitator talked with her a while and learned enough trust to learn that Mercedes had, in fact, stolen the shoes of another girl, but that she and that girl had been fighting for years and they didn't know any other way to communicate. So they all agreed to attend a confidential conversation facilitated by the trained leader. And there they each initially expressed anger. But then Mercedes apologized and she explained she had stolen the shoes to sell them in order to help her mother pay for a drug test. If her mother could show she was clean and not using drugs, she might be able to get the state to return Mercedes' younger siblings home from state custody where they were in protective care. She cried as she told this, and the other girls cried too. And they said they wanted some reason to trust her going forward, but they didn't expect her to pay them back or return the shoes. That kind of practice, restorative justice, has become more widespread in some communities. It's now used by the prosecutors in the District of Columbia, and there's a teen court in Los Angeles that uses similar methods. So this is one form of law and forgiveness. Law can actually construct a setting where individuals can forgive one another, and the law itself can be less punitive. Another example that may seem quite different, but I think there's a lot of connection, is the treatment of debt. Personal debt, business debt, municipal debt, sovereign debt. The concept of debt infuses Western and Christian morality in particular. It's not by accident that forgiveness is a concept that we use in describing debt as well as criminal violations. And the legal mechanism of bankruptcy implements the idea of forgiveness by allowing individuals and companies to declare they are insolvent and discharge their debt, obtain immunity from any suits about those debts in exchange for meeting certain requirements. The requirements may include financial counseling, selling off assets to repay creditors, restructuring a payment schedule, and so forth. And certainly one consequence that's not a legal one, but an economic one, is someone who declares bankruptcy receives a poor risk rating when it comes to future loans and has to build back credit over time. Like spiritual forgiveness, bankruptcy represents the chance to start anew. In the United States, the nation actually was founded with a commitment to making bankruptcy available. Thomas Jefferson, one of the founding fathers, argued to his friend James Madison that each generation should be able to start fresh and not carry the debts from the past. I think this reflected in part the fact that Jefferson was himself in debt over and over again during his lifetime. But as a result, the US Constitution actually gives authority to the federal government to create a bankruptcy law. And we've had a bankruptcy law on the books since the 1780s. A nation, however, cannot declare bankruptcy. And that's a serious issue. It was an issue that worried the founding fathers because they had debts coming out of the Revolutionary War. The development of informal mechanisms to deal with sovereign debt is an area of great interest to me. And also the possibility of municipalities declaring debt, as has been done by Detroit, Michigan, for example. Some debts that lie outside of bankruptcy include higher education debts in the United States. They are excluded from bankruptcy. This seems wrong to me. Just take an example. A for-profit company that runs a school can declare bankruptcy, but the students who took out loans to go to that school cannot. So there's politics involved. And I think we need to be much more careful about the justifications for forgiving debts. Drawing from the biblical notion of a Jubilee year, clearing the slate of all debts, a nonprofit organization called Jubilee Network mobilized faith communities and other groups to deal with developing countries' debts. And they actually organized a successful effort to abolish some third world debt and to develop mechanisms for reducing it. The Pope was involved and rock star Bono was involved. Bolder proposals to abolish odious debt, debt that occurs when government leaders borrow funds and profit themselves and not their citizens. That's a concept developed by economists. And I guess I would treat that not as forgiveness, but as justification or excuse for non-payment. I've been very fascinated to see some philanthropic efforts in the United States take a page from commercial debt practices. Commercial debt collectors purchase bad debt and then collect pennies on the dollar by garnishing wages and harassing the debtors. An organization called Rolling Jubilee was founded to purchase consumer debt the same way, pennies on the dollar, but rather than collect it, to simply forgive it. And actually, John Oliver, television host, did exactly that. And for about $70,000, he forgave millions of dollars of consumer debt and medical related debt. I think that the law could actually support favorable tax treatment or other incentives for this kind of debt forgiveness of consumers and students and medical debt. Now, implicit in my discussion is a big question. Are there some wrongs that are unforgivable? That's undeniable, I think. I think it's hard to imagine forgiveness for genocide, for the rape or abduction of children. There are some acts that are so unspeakably horrible that even talking about forgiveness seems to be an insult to the victims and the survivors. Legal systems around the world assign no statute of limitations for murder, I think, out of similar views. But philosopher Hannah Arendt claimed, we cannot forgive absolute evils that are too large or radical to punish. And yet at the same time, she argued for the development of forgiveness. Forgiveness by individuals, groups, and even governments is a valuable resource. Indeed, it's a resource even when other resources are scarce. Promoting forgiveness, however, can jeopardize predictability and reliability and equal treatment sought by the rule of law. So that's why I think we need a jurisprudence of forgiveness. When should forgiveness be used by the law and when not? In this light, individuals who become child soldiers, I believe, should not be subjected to international criminal sanctions, but they should not be categorically exempted from accountability. Alternative mechanisms of accountability would serve them and their communities. The efforts to reintegrate child soldiers could inspire greater uses of restorative approaches in domestic law as well. I've suggested that sovereign debt could be eligible for forgiveness or restructuring, and that bankruptcy is valuable in itself and also offers a valuable metaphor for fresh starts. And maybe there's even a metaphor with regard to rebuilding the credit rating. Maybe in the context of crimes, there's a similar social process of rebuilding the trust. I think we need to guard against turning to forgiveness solely when more robust justice is not available. That sometimes seems to be the case. People talk about forgiving because prosecution is not happening. I think nonetheless, there are valuable uses of forgiveness. One caution is the moral hazard. Forgiveness may encourage more violations. The economists call it a moral hazard because if you forgive misconduct, then people may be willing to engage in more misconduct. These are the issues that arise when we face questions like amnesty for immigration violations, pardons by a chief executive for lawbreaking. But I do think that there are resources that the law itself can use. And I don't think it's by accident that legal systems around the world and across time have built techniques like pardons, like bankruptcy, so that we can halt escalating resentments. We can have a restart, like the Jubilee. We can start over, start fresh. And to ask how law can forgive is not to deny the fact of wrongdoing. Instead, it's to widen the lens to enable a glimpse of the larger patterns that are at work, that cause the problems, and to work for new choices that can be enabled when we wipe the slate clean. Thank you. Look forward to your comments and questions.
Thank you so much, Professor Minow. Such a fascinating and rich presentation. So we have a nice chunk of time for discussion, questions, comments. Maybe I'll get the ball rolling, if that's okay. You spoke about several different spheres, sort of with a wide expanse. You talked about pardons, and you talked about child soldiers, and you talked about debt. And I think that's one of the suggestive things in your presentation, that you're trying to sort of look at a bunch of different spheres and see if there's some common threads while acknowledging differences. Nevertheless, I still wonder whether, the differences matter in some respects. And let me try to focus in on this sphere where I think was more in the opening of pardon in a criminal context, even before we get to the international, sort of in the national sphere, which is where pardons are used at the federal level in the US. You spoke about the institutional responsibility, the role of law, and the role of political actors, and the role of the sovereign. And what I didn't hear as much in the discussion was about what falls on the shoulders of the wrongdoer. And especially in terms of not just responsibility, but a sense of having done wrong, apologizing, regretting, repenting, especially if you're going to borrow some of the religious traditions and earlier traditions. That seems to be a very central piece of the puzzle. It's hard to move on. Certainly interpersonally, we'd expect that the only way we can repair is through a keen awareness of having done wrong, acknowledgement, a taking responsibility through apology, through confession, through regret, through repentance. And when we move to, the sphere of law and the sphere of institutional actors, I wonder, is there a way to institutionalize that? Does that play a part of the puzzle? When you talk about restorative justice, you sort of, I think, interpolated that, or you brought that in, but I felt like that was through one compelling example. And there was, sort of a conversation and a healing and an apology and an explanation and a context, but that it's hard to see how that would get institutionalized. So is that important? Can we move on without that? How would that fit into the scheme?
Thanks very much. It's a great question, and it's a very Jewish question. So I can tell you that I've done a little bit of study, and now I've talked with many other people about the concept of forgiveness and practices of forgiveness in other traditions. And it is very important in Jewish tradition to have the process of teshuvah, that there has to be some kind of acknowledgement and apology and restitution, that we cannot seek forgiveness from the Almighty for violations we commit against human beings. We have to seek the forgiveness from human beings. This is not so much the tradition in Christianity. Christianity, some forms of Christianity actually hold up forgiveness without any action on the part of the wrongdoer, that is more divine. So I don't want to have a theological debate, and that's one reason that I haven't dealt with that so much. But you're right, in the restorative justice practices, that opportunity for individuals to take responsibility is always a big part. When I turn to the role of the legal system itself, when should the legal system forgive? Should the legal system, for example, give a lesser sentence to someone who takes responsibility? Should that be written into the code? I was very struck in talking with the commissioners of the Truth and Reconciliation Commission in South Africa while the commission was going on. And I asked them this question. I said, you've set up a system that gives amnesty to people if they simply tell the truth, even if they committed grave violations of human rights. Why don't you make it conditional on their apologizing or making amends? And I really can't get out of my mind the response I got. The response I got was, well, then we will never trust any apology. Then we will never trust any effort to make amends, because all of them will be done under this promise or incentive. It won't be genuine. And I guess that's sort of where I am right now, that I think, as Moshe Halbertal says, the law can bring people close enough in proximity so that they have the occasion for that act of expression, of contrition and apology. But if the law requires it or induces it or rewards it, it's not an actual turning of the individual. So I think that's where I land on that subject. I think when we talk about something at a more societal level, the use of, say, transitional justice mechanisms to help a country overcome a civil war, or deal with something really as grotesque as like the Holocaust. I think it's not by accident that reparations come into the discussion. Never enough, but one sign of the sincerity of a desire to make a new start.
I just want to add, I hope it's okay, just one comment, which I'm going to get a little political here, but I can't help it, that I worry in our society in the West, I'm talking about the US and Israel and other Western societies, that the role of accountability and apologies has really become so eroded. And I'll single out President Trump as an example. One of the striking, I really think, strategies of President Trump is to never apologize.
Yeah.
And it seems to be extremely effective. Following some New York politics, I'm a native New Yorker, Governor Cuomo is basically not very shifty around apologizing and owning. Now, we get it, and it's sort of extremely frustrating. It seems hard to know what to do with that. The old move, the classical move, was to give sort of the theatric public apology, and we seem to have moved from that. So I wonder and worry about, when we speak about forgiveness without apology, where that leaves us.
Well, as a political matter, of course, I agree with you entirely. And, Trump has made these topics only so current, and also the behavior of never apologize that's become now associated even with never even tell the truth. Very, very disturbing. And I think we have also a public display in the Me Too movement of people who want forgiveness without apologizing. I actually think that we need a curriculum, probably starting with young children, but if they haven't had it, older children, students, adults, to what is an apology? It's not an apology if you don't take responsibility and actually undertake some acts to make your victim better off, I think. And we have these examples in public life of the non-apology apology, no active verb. If anyone was hurt, I am sorry. So I think you're quite right. There's been an erosion of these practices that are fundamental. Again, every society, every religion, every civilization has honored forgiveness and has honored apology, has honored these practices. Studies of large mammals, of apes, show that they engage in forgiveness rituals. It is a resource to deal with the understandable conflicts and at times horrific conflicts that people inflict on one another. We should cultivate it and use it.
Great. Yael.
Hi. Thank you very, very much. It was very interesting. It's actually some sort of follow-up to your discussion with David right now. I was interested to hear your thoughts about the connection or maybe tension between forgiving and forgetting, because connecting to transitional justice mechanisms like truth and reconciliation committees, but also to law generally, does law enable forgiveness because it has this transcript and it enables it protects from forgetting? Or the other way around, is the law's focus on the end goal, convicted, innocent, forgiven, somehow the haste to get to the end goal is in tension with that, is encouraging forgetting in some way? What are your thoughts on that?
So wonderful, wonderful question. And I have thoughts, but I have no answers. I think that you present the alternatives, which are both true. They're both true. Here we are, the 75th anniversary of the Nuremberg trials. The Nuremberg trials are rightly held up as making denial not possible because we have a record. We have the court record. We have the transcripts. And that's true in one way. In another way, the claim that there's closure, that it's over, is part of the problem then about memory. And you see this in all settings where there's transitional justice, and people from the dominant group say, we've done enough already. So it's very striking to me to see that people who've been victimized never say we don't have enough memory. It's only the people who have more privilege who say enough already. So I think paying attention to the power dimensions is one way to think about the dilemma that you point out.
Thank you.
Amy.
Just as a quick follow-up to David's point, I believe that in Judaism, forgiveness is more of a response, or it actually is a response rather than an initiated step. And I had two quick questions. One is, rather than the fresh slate, which is an extreme, I was interested by the pay-as-you-earn mechanism you mentioned in your article. I was wondering if rolling Jubilee ever thought, because what does that do? It eases the burden, and then it incentivizes if a person knows they can make it just that far, and then there's that incentive to learn how to make it just that far. And then my third question involves regulation. Is there any regulation on the creditors, like, for example, once a person has 3 credit cards, that a creditor is not permitted to even render available additional credit?
Oh, such good questions. I mean, there really is a sharp emphasis in Jewish tradition, but others here know much more than I do, you know, that the burden is on the one who's been apologized to forgive. If you've been apologized to 3 times, the rabbis say, and you then don't forgive, then the burden shifts. But the obligation is not to forgive without the apology. That is a very Jewish approach. And as I say, it's just not true in some other traditions. In Buddhism, it's not true. Buddhism, it's letting go without any behavior on the part of the other. So legal traditions, of course, reflect in part religious traditions. But what I really like about your question is really questioning the all or nothing quality of forgiveness. Why does it have to be all or nothing? Why can't there be gradations? And I think there can be. And to use an example, both from criminal law and then an example from more the financial settings, on the criminal context, you know, the act of contrition or apology can lead to a lesser sentence, but doesn't have to mean there's no prosecution and no sentence. A case I heard of recently that I liked very much was a criminal defendant who had accidentally killed someone, but he'd actually punched him and then the man died. He participated in a circle and he apologized. The prosecution went ahead. The prosecutor took note that the family was moved by the apology and they gave a lesser sentence, but they didn't forego the prosecution. And I think that there can be a compatibility between criminal accountability and degrees of forgiveness. There doesn't have to be all or nothing. And on the financial side, absolutely. I think that there can be, in many ways, bankruptcy often takes the form of partial payments, restructured payments, as you say, a pay-as-you-go process, requirement of paying, you know, for 10 years, and then the debt is forgiven. So there can be not something other than all or nothing. It's obviously easier to talk that way when we're talking about money, because we know how to subdivide money. We're less good at subdividing less concrete forms of blame and debt. And there, I think we need some creativity.
I want to invite and encourage the official students in the workshop, along with everybody else, to join in the conversation. I'll call on Benny next, but afterwards, we'd love to hear from some of the students also.
Well, thank you very much. It's very fascinating, and I also want to reflect from Jewish law perspective, from the Jewish perspective, and maybe we should put a distinction between having a fresh start and opening a new page and repentance and forgiveness, because no doubt that Jewish law suggests an idea of having the right to have a fresh start with regard to the Jubilee and debt cancelment and releasing slaves, and there are other examples as well. But with regard to repentance, I think it's more complicated, and it's complicated because on the one hand, there is no doubt that Jewish law supports the idea of repentance and forgiveness, and it's not only an opportunity; it's also a commandment and a heavy duty, and God forgive to the sinner after having repentance. And there is a lot of writings that after repentance you are considered a new person. And it's not you that made the sin, but it's someone else, on the one hand. But on the other hand, Jewish law thinkers in the last 400, 500 years pay attention to the fact that there are no legal effect to the idea of repentance. And if someone was murdering someone else, and now according to the official law, he should be executed, and he made a full repentance while he was in prison, according to Jewish law, he will be executed. And if he claims that, listen, you told me that after repentance, I'm considered a new person. It's not me that sinned. We will tell him, sorry, this is only between you and God, but on the legal arena and the legal spheres, there are no legal consequences to the idea of repentance, and you will be executed. And it's very surprising, and there are a lot of interesting writing about what is the reason for this distinction. Here are two examples of writing from the last 200 years. So one suggestion that, and you mentioned it from one direction, that we don't want to incentivize false regret and fraud regret. So in order to not to give a positive incentive, so there are no legal effects to repentance. This is one answer. Another more interesting answer, that regret, it's something that we cannot measure and we cannot verify, and regret, it's something that only God can verify true and genuine regret, and it's not something that the court can measure and assess. However, it's very interesting that Jewish law holds two separate dimensions simultaneously. So with regard to the relationship between man and his God, there is a full option of repentance and forgiveness, but with regard to the dimension of a person and court, there are no option of forgiveness. And here is final thought. Maybe Jewish law as a religious tradition can hold these two dimensions simultaneously, but when we move into the secular state, and where the state replaced God, or the law replaced God, so we don't have this privilege to have these two separate dimensions separately, but we don't have option but to have forgiveness and repentance within the law, and it might support your argument, but from a different perspective.
Oh, that's so very, very interesting. And I think that the idea of the two spheres in tension actually even operates daily in this country, where, just take the example of the horrific mass shooting that happened in South Carolina in a church, and a white supremacist came and just shot people in a prayer circle. And many members of the family members who had, of those who were killed, later forgave this man, Dylan Roof, for his mass shooting. And people said, how can you do that? And they said, well, we're not saying he shouldn't be punished. He should go to jail, but we forgive him in our hearts. And they viewed it very much as a religious obligation that's entirely apart from what the secular state should do. So it happens even now, even with day-to-day practices in the United States. I think that the tension is so very, very profound, and it's also captured in a lot of ambivalence about the pardon power given to the chief executive. So the presidential pardon power of the United States derives from the king's pardon power in England. The king's pardon power was supposed to be an extension of the king as a divine authority. So we still have ambivalence. Is this 100%? Can the presidential pardon mean that there's no consequence for someone who's done something terrible? That's what the law says, but a lot of people don't like that and think there ought to be rules and limits on the use of the pardon. But I think that ambivalence shows this effort to integrate in the secular system something that had a divine authority behind it. The point that seems to me so just undeniable is that the ability of a person to convey to others that I have changed, I have turned over a new leaf, I am a new person, may turn more on their ability to be a good actor than on anything that's internal. And only a divine authority could actually see what's genuine and what's not genuine. And here's again where the danger of making the show of contrition or apology itself a precondition for lesser sentence or lesser punishment. When people have different personalities, different cultural traditions, just take the analogous issue, the signs of credibility in giving testimony In one culture, it's looking someone in the eye. In another culture, it's not looking in the eye. These behavioral manifestations of an internal state, they can be pretended, they can be feigned, they can be fraudulent. So it is a major difference. I think that what I'm really pressing for, therefore, is treating these two issues, the law's role in prompting interpersonal forgiveness on the one hand, and the law's role in forgiving itself, as quite different. So for the first, I think it's valuable to think about when legal institutions can bring people together so that they can have the exchange, but not to reward or punish forgiveness, because then it becomes it risks this issue of fraud. And on the other hand, I think that any punitive system does have to have something like a jubilee. It has to have an ability to have a reset, because it can go off course.
By the way, that's another example. Jewish law, for example, as distinct from other ancient legal systems, don't have the institution of pardon, and this right. Precisely because the idea that the king is not considered as divine, and therefore the king or the ruler or the monarch does not have this privilege of pardoning other.
Right. Yep. Now, I'll just make a comment about the phrase "wipe the slate clean." This comes actually from British pubs. So if you're there drinking and you're running up a tab, it was traditionally on a blackboard, on a slate. And periodically, the owner of the pub would say, "We're going to wipe the slate clean." And that's where it comes from, starting over.
Now you've changed our whole frame of reference. I invite some of the students. We'd love to hear some questions or comments.
Well, I'll ask a question directly. Do you think that the law should reward people who show that they're sorry?
How would students are never shy. Yeah,
I'm not a student. I'm barging on your workshop. I'm not a student. But how would they show sorry?
I know, it's a tough thing. There are legal systems in some countries that actually require a criminal defendant to prostrate himself or herself, to bend down, to physically manifest apology. But again, it's a performance.
Yeah.
There was a case a few years ago in Jerusalem where there was a fight between two people in Jerusalem, and the one who hit the girl was convicted, and then he apologized in court, and the fact that he was white and the one who was attacked was a black girl, and then the judge at the district court in Jerusalem recognized the idea of asking for apology and regret. And he also added another sentence about the fact that this miserable black girl had the opportunity to forgive. And it made a huge provocation in Jerusalem, because in this very miserable sin, the forgiveness of the one became to be a kind of a humiliation to the one who was a victim of this attack, and instead of contributing something to her status, all of the sin was against and dehumanizing her. And it was very interesting to see the reaction between the attacker, the victim, and the judge with regard to asking for forgiveness.
It's so very interesting. You know, at some fundamental level, the ability to forgive has to include the ability not to forgive, because otherwise it's not the elevation of the victim to be in a position of authority and power. And if it's being played out in a public setting like a courtroom, it's not clear that there's actual freedom to forgive or not to forgive.
Yaakov.
Yeah, thank you very much for being with us. It's really a pleasure and an honor. And I would like to react or to continue what Professor Parag started. I would like to ask you if you think there's a point where the law stops, and instead of talking about forgiveness, maybe I'll ask it differently. Is there another word rather than forgive debts? Because in Hebrew, we can say to, I don't know if we say that in English, but we can say, and it's like that in other languages, to erase a debt. And it's like to wipe the slate clean, like you said. Now, why am I asking this? Because forgiveness, and I think it's still like that even nowadays, has quite a religious connotation. Now, when we talk about bankruptcy, do we place creditors or even the court as sort of a spiritual authority that can say, I absolute you from your debts, I free you from your debts? Or do we do something else, which is more of an economical interest? Now, when we talk about forgiving, and I think it's different in Jewish law, because we know Jewish law has those laws with that free the debt holders from the debt every 6 years and every 49 years. But there's also another law that applies at every step of the debt, and it's the forbiddenness to request a debt from someone whom we know doesn't have the money to pay it. And that's true on every stage of the debt. Now, it's very precise, and it goes to very precise cases. But what I think it shows is that the forgiveness we talk about is more an education of the debt holder, teaching him to let it go. And at some point, but he's not forgiving from a position of strength. I do you the favor of forgiving. He's forgiving, and that's why he has the mitzvah of forgiving, and he has to do it on itself. Even if the other one wants to pay, he has the commandment to forgive, because it's a commandment that teaches him to let it go, and sort of saying, I don't know if it's academically right, but sort of saying, you held out without that money until now. Maybe you can go on without that money from now on.
It's such an interesting question. I can answer it partly. There are two elements. One is a historical perspective, and then one is maybe a current functional one. So historically, it's not by accident that forgiveness is the word in English and Latin that's used in both contexts. And a lot has to do with the impact of Christianity on the formal legal systems. The Lord's Prayer, forgive us our trespasses. In some of the versions of the Lord's Prayer, it's forgive us our debts. They were interchangeable. And indeed, the people who have written about the history of debt and debt practices in Europe and in the United States explore how it had a religious dimension. Even though, come fast forward to the present, we don't think about debt as having a religious dimension. But the reason it did have a religious dimension was that debt was a promise. It was about a broken promise, and a promise is sworn to God. And therefore, this was everything. If you live a religious life, everything has a God dimension, and certainly promises do. So then the second answer is on the functional point. I think that we can certainly use a different word like erase or clear the debt, start over, and we could make it just pragmatic. It's just because you can't get blood from a stone. You can't get money from someone who doesn't have the money. And a lot of commercial practices really reflect that. But I actually think that there's something missing if we do that comes from the spiritual background and the religious background. That sense of humility that you described, that it's a mitzvah to forgive a debt, that we understand we are all implicated in each other's lives. We are all flawed. We are all capable of having a falling away, of missing the mark. We each can have that. That is a humility-inducing practice that is good for commercial practices, that is good for criminal practices. And I would be sorry to lose that.
I just want to make one comment on the religious language, that there's also, I think, a related dimension that a lot of early religions tend to conceptualize sin as debt. So that's actually a complicating factor.
Quite
so
right.
The spiritual, but there's also the, you know, the ledger in the spiritual plane as well.
Absolutely, absolutely. And in same, you know, I've had many people say, why are you putting together debt and crime? Well, that's what in the ancient times it was. People were incarcerated for debt. That debt was a way of talking about crime. That sin was it was the divine ledger about wrongdoing.
I think it still is. Isn't it still the case in Israel? The imprisonment of debtors was only canceled a few years ago, 5 years ago. Until then, you could still lock up people because they were in debt. And I think it has a lot to do with the corrective bankruptcy. Generally, has a lot to do with trying to correct some wrongdoing, and talking about it in terms of forgiveness. It reflects exactly that. That is still, we perceive the poor people in poverty as done something wrong to the society.
Blameworthy. Well, the United States Supreme Court banned debtors' prison, but we still have it. So we have it because people are put in prison for failure to pay the fines and fees associated with their criminal liability. And so now there's a massive movement to challenge that.
And as Amy just noted me in the chat, in Hebrew, is a word to make a sin and to have a debt. It's the same word. It's to be chayav. So to be chayav is to have a debt and also to make a sin. Yeah, it's the same word in Hebrew.
Ben's been waiting very patiently. Ben.
Yeah.
Hi. First of all, thank you so much for such an interesting talk. I was wondering if you could say a bit more about the right to forgive, and if you think that there is a difference between an individual's right to forgive and the community's right to forgive or
It's wow, that is a very profound question. You know, the lawyers talk about standing, who has standing to bring a claim, who has standing to forgive, who's in the right position to be able to forgive. And it comes up also in the question, who's in the right position to be able to apologize? So if you have a government figure who apologizes for something done in the past, are they able to do that? You know, the wonderful book called The Sunflower that was written by Simon Wiesenthal about his experience as a soldier in World War II, where he was brought to the bedside of a dying German who said, "Do you forgive me? I need someone to forgive me." And Wiesenthal, as a Jewish man, he says, "I am not in a position to forgive you. I am not someone who was killed. I can't speak for them." So I think it's a very profound and challenging question. I think that if we really try to keep straight who has the authority to forgive, I think that, you know, probably no one can ever be forgiven for murder because the victim is gone. The surviving family members maybe can forgive for the loss of their loved one, but they cannot forgive the killing of the person whose life is gone. And so, but if we follow that to its fullest extent, then there won't be much forgiveness. So I guess one way that I've come to think about it is to distinguish these interpersonal moral issues about who can forgive and not from what are more societal. And at times, you know, to have a stand-in for the actual victims can be important as part of a social process and social ritual, particularly in the context of transitional justice.
Rinat.
I think you're still on mute. Yeah.
sorry. It is fair to say that if forgiveness should not be dependent on apology, and if only God can judge, so it is fair to say that maybe the punishment should not be based on reward, but on other considerations such as deterrence and incapacitation, but not on retribution, reward. And, what do you
Interesting. Think? So now we get to
Christianity. If, you know, Jesus do not judge in order not to be judged, etc.
Oh, turn the other cheek, right?
Yeah.
So yes, so very interesting. And what are the purposes of laws? It really comes down to that. Is the purpose of law educational? Is it trying to induce different behavior? Or is there a larger balance of right and wrong where the wrong has to be met with another wrong? These are profound questions. And how much do we answer them by asking, well, what works? What deters crime, as opposed to, it's not just a matter of pragmatically what works. So I very, very interesting. I mean, I think that to actually use the language of forgiveness in the context of crime is to acknowledge that there's something more than simply the cost-benefit inducement of deterrence going on.
Okay.
Benny.
I would want to have another question, and I want to go back to the idea of cancelment of debts, of the biblical idea of cancelment of debts. And if we move on a few hundreds of years to the 1st century BCE, then we find Hillel the Elder abolishing the idea of cancelment of debts. And the techniques, how it is less important to in this context, but what's more interesting is justification of Hillel the Elder, why we have to abolish the idea of cancelment of debt. And his main idea is that if we will apply the idea of cancelment of debt, so the problematic consequence will be what we will call today overprotection. That in order to take care of the poor and to cancel their debts, the result will be that no one will give them loans. And deep down, I think the idea of Hillel the Elder is that at some point, granting the idea of fresh start, of new page, of forgiveness, might at time, if you think about them as repeated players, that they will suffer more from this institution than we would be thinking at the beginning. So at the first circle, it might be very interesting to have a new fresh and to have a new page and a fresh start. But then at the second cycle, no one will give them debts, or no one will have them the opportunity to go in streets, because everyone knows that they can do whatever they want, and they will be they will have forgiveness, and then the debt will cancel, they won't be executed, or so on and so forth. So what will be the results? Maybe we can frame it from economic analysis perspective about this kind of forgiveness. What kind of incentive it gives to sinners and to those who have debts?
So this is, of course, very much what the economists talk about in dealing with debt and debt forgiveness. And this subject I touched on, odious debt, is a big field of economic research. Should there be cancellation of debt in developing countries when a corrupt regime incurred the debt? And a lot of the response is no, because then that country will never again be able to get loans on the international market, just what you're saying. And when I have spoken on this subject to audiences with people from around the world, the people least interested in forgiving the debt of developing countries are those in Africa. My students and professors that I've met from developing countries in Africa say, we don't want debt forgiveness because we will never be able to obtain loans. But this reminds me of a question I didn't answer, which is, take the credit card companies that keep pushing credit cards on poor people, and they have no consequences. So I guess I think that the rounds that you rightly described, the first round, and then there's a second round, and then there's a third round. I think that there should be some consequences for the behavior of the lenders who do not do their due diligence to find out, is this grant of money going to the developing country going to be used in a way that they say, or is it going to be lining the pockets and feeding the corruption of the leader? And if they don't face any consequences, they will continue to do it. The same with the credit card companies. If they don't face any consequences, they will continue, and they do very sophisticated techniques. Someone declares bankruptcy in this country right now, they immediately get offers of credit cards. There's something wrong here. There's something terribly wrong. And the use of the behavioral tricks to induce someone to sign up for a new credit card and not understand that there's a balloon payment at the end that will destroy them and their families. So I think that the first round, second round, third round of the economic analysis needs to be incorporated in the law, that we need to come up with a way to anticipate how the larger consequences should be internalized by the players on both sides. You know, the fundamental image that I have is that we are each unique individuals, but we're also in concentric circles. We're in larger and larger circles, and whether it's debt or crime or any other relationships, what we do, we should be responsible for. But we are also part of a larger context. And those people who are in part responsible for creating my context, they should face some responsibility too. And we need, it seems to me, to create rules about bankruptcy, rules about criminal law that take this into account. At its very best, I have a new project now trying to look at what does anti-racism look like in the context of restorative justice? Because there's a risk that if you collapse the issue just into these two people, you're not seeing the larger context is one of racial injustice, economic injustice, other kinds of injustice. Why does all of the blame get placed on the individuals where the immediate conflict happens when the source of the conflict is spread? We need to come up with legal rules that spread the responsibility. And I think we may have better success doing that in the context of debt. It's easier to distribute portions of the responsibility than we do with crime.
I actually have several questions. I'll just articulate them if that's okay. And then whatever you want to comment on, that would be great. I would love to hear your thoughts. I think we'd all love to hear your thoughts about our current moment, and especially the cancel culture and that phenomenon, and how forgiveness and the cancel culture intersect, and what we do, and have we gone too far? How do we respond? That's one type of question. The three pretty different kinds of questions. Second question, I have to read the book more carefully, but I'm sort of not sure I know where to locate your thesis in terms of how much fluidity and discretion and flexibility and spontaneity is ideal, and how much things should be sort of fit into. You use the language of a jurisprudence of a forgiveness, but then you also talked about, I don't know, it's more like procedures of. So it sounds like you do sort of have a certain preference to not just leave things at the whim. I know you're nervous about inequalities and things like that, but is there room still for, if we go back to beginnings, Aristotle, equity, it's more ad hoc. And the way we correct justice is through sort of intuition, ad hoc, wisdom, case by case, or even prosecutorial discretion. Is that a bad thing? Should, let's turn to an arena where maybe we trust the actors a little bit more than a politician, but still, is that type of discretion good? And then the third question, I hope that's okay. The third question is really sort of a meta question, which is, I think, very relevant to us in the Jewish Law Workshop. And that is, I really feel like we're kindred spirits in the following sense. We really learned from you in many ways, but also in the following larger way, that you're willing to raise these sort of large questions about what are our blind spots in society, in law, in our legal systems, and what are certain sort of idioms or axioms or conventions that we repeat, and what are we missing? And I feel like in this sense, that you know, at least in part, it goes back to Robert Cover, who's, you know, it challenged us to look at our, you know, Western traditions in conversation with other traditions, and to try to see, you know, for example, his famous example of rights, but what about all our obligations and our commitments and our responsibilities? And I was wondering if you could say a little bit more about your sense of the importance of that project and how to go about that project. And what are the right ways to make those interventions in legal education and in law?
Small questions you're asking, but very, very good ones. Very, very good. Thank you. I'll try to say something. I wrote something about cancel culture and also about the current state of the United States, where the only thing that people in the United States agree about is we don't agree. We don't agree about facts. We don't agree about what happened in the election. We don't agree about anything. And is forgiveness a tool here or not? And I am less convinced that forgiveness is a tool, but I am convinced humility is necessary. You know, even as I am convinced I am right and the people I disagree with are wrong, that's part of our problem, that we all feel that way. Cancel culture is, of course, a phrase that has been invented by the right wing and now is used by everybody to talk about the readiness to wipe off the slate, particularly in social media, but anywhere, anyone who has crossed a line. And forgiveness is the missing ingredient, it does seem to me, but then we have too many instances of people being expected to forgive when there hasn't been any kind of apology or wrongdoing. So again, I think here we need much more practice on what it takes for forgiveness to be justified and warranted. I do think social media has accelerated these tendencies, the erosion of apology, the readiness to cancel, to remove. We will see if Trump remains excluded from Facebook. This is, of course, the subject in lots of news debates. The Fox News, it's an offense that he has been deplatformed. In other places, it's self-defense, it's safety against incitement. These are very, very profound and, you know, very immediate questions here, and we're not in good shape about them in the United States. I could say more about that, but there won't be so instructive, and I'll just send you the link to what I wrote about this. I wrote it before the insurrection of January 6th, which makes it even harder. You know, on the issue of can there be rules of forgiveness, isn't that the opposite of what forgiveness is? You know, I think about this a lot in terms of the history of law and equity. So in Anglo-American traditions, we had two legal traditions. The court of equity was supposed to be the Kadi justice, the case by case, the you can't have rules. But we know that over time, the equity courts developed even more ridiculous and rococo rules, more elaborate, more rigid, more structured. It seems as though there's an ongoing dialectic and tension between the formal statements of rules that then are too strict and need to be modified, and then the modifications need to be modified. And I just look at the United States, which is, of course, the country I know best, and I see that we have tilted so far in the direction of punishment in the criminal system and in bankruptcy also. And we could use some tilting back in the other direction. Not that there will ever be a permanent, but yes, I'm worried that when we do so, we may then unleash the forces that led us to be rigid, which are, you know, biases and badly handled legal systems. Particularly right now, the risks, of course, of bias that is racial or economic. And so what I'm wondering is, can we learn from the past cycles, the dialectic, and have a synthesis and in the synthesis develop, if not rules about forgiveness, yes, maybe procedures, you know, on the particularities of, say, a presidential pardon. I think we could learn from other countries that have said pardon power is good, but it shouldn't be given to one person without checks and balances. There should be a process, there should be a group, there should be a review board and so forth. So procedure is, of course, where lawyers go, and I like procedure, I teach procedure, but I think there might even be some substantive norms with the acknowledgement we're never going to get it right. It's going to always be an ongoing process. And then on the big meta question, I always try to ask, what am I not asking? What am I not seeing? And one reason that I guess I'm so committed to diversity is that I know that if I'm in a room with people with different backgrounds, I'll hear something I didn't think about. I learned something yesterday. The Department of Defense in the United States uses what it calls two-teaming to guard against errors. So they have two teams to check something. And I was offering that to a computer scientist as a way to deal with the issues of mistakes in algorithmic decision-making. And she immediately said, that doesn't work because the people who are computer scientists, they're all trained the same way. They're gonna run the experiment the same way. They're gonna see it the same way. She said the same thing in the Department of Defense. They're not gonna catch each other errors. They're trained the same way. So I'm thinking hard about that and how do we come up with ways? Who's the we? Who's coming up with the ways to think about what we're not thinking about? I am very convinced that the United States has tilted so far in the direction of rights and failure to bolster the content of obligations. And that's a cultural issue even more than a legal issue. But it's one of the many reasons that I'm sure that Jewish law has a lot to offer secular law in the United States.
What a treat. I feel like that was just fantastic. We were so honored that you joined us. We really hope that we find ways to continue the conversation. And I really want to, on behalf of all of us and the Jewish Law Institute, thank you so much.
Thank you for the honor of the invitation. It's great questions, great conversation. Thank you very much.
Thank you very much, Professor Minow. Thank you.